Thank you for joining me today. My name is Dr. Olive McBride and I'm a geriatrician practicing in Australia. The information that I would like to share with you today is mainly relevant to Australia, and so I urge you to please check your local laws and policies to determine what your local laws are. Highly likely the information is similar, just comes under different names. So today I'd like to talk about legal issues and how they relate to the comprehensive geriatric assessment. So when you're seen by a geriatrician, they may ask you questions about what your current health issues are, what your previous health issues are, what medications you're on, and then they'll ask you more personal questions, which maybe other doctors may not focus on, but as a geriatrician, they are quite important. And some of these questions would be where you're from, what your family structure is, if you have any family conflict, if there's any family members who are not, who are estranged. And then they'll ask you things about whether you've had a will done, power of attorney, and enduring guardian. Now, when I ask these questions to some of my patients and their families, sometimes they get a bit offended, and I have to explain to them that I'm going through a checklist in order to help them. So if I find that they've not done their wills, I would then check the testamentary capacity and provide them with a letter to give to their solicitor. If you were to go to your solicitor now to change your will or make a new will, if you have a diagnosis of dementia or cognitive impairment, it is highly likely your solicitor will ask for you to be seen by a geriatrician to get a letter indicating your testamentary capacity. Now, just because you have or your loved one has dementia does not mean that you no longer are able to change your will or write a new one. But we would have to make sure that you fully understand what you're doing and understand the implications of a change and understand the implications of having the beneficiaries listed as you wish. As sometimes when there are families with conflict, it is possible that you may not include a certain family member, and then later on after you've passed, the will may be contested. So after you've been assessed by a geriatrician, if it is deemed that the person no longer has testamentary capacity, then they are no longer able to write a will at that time. But I do know that with time, sometimes people's cognition improves, even though this is rare, and they will need to be assessed at a later time should they want to change their will. Now, with dementia, people have good days and bad days, and it is possible that as their cognition fluctuates, that there are moments that they would have testamentary capacity, and there are moments when they would not. So, for example, if your loved one tends to sundown, and this is a phenomenon where the confusion is worse in the afternoon, but they are quite cognitively as good as could be in the morning time, then we would urge you, if the patient is determined to have testamentary capacity at certain times, that you'd make an appointment to see a solicitor in the morning. And even with the letter from the geriatrician, the solicitor will ask the patient questions to make sure that they know what they are doing. And if it is deemed that they have testamentary capacity, then they will be able to make a new will. Now, on to power of attorney. So a power of attorney would manage your finances while you're still alive if you were no longer able to manage them for yourself. That's an enduring power of attorney. When you appoint someone to be your enduring power of attorney, but you still have the ability to make your financial decisions, that power of attorney does not step in and make decisions for you. You have to have lost your capacity to make financial decisions for yourself and get a letter from either your general practitioner or from your geriatrician or another doctor who knows you well, who's able to assess at the time that you no longer have the capacity to make financial decisions for yourself, and to provide a letter to enact the power of attorney. The same goes for an enduring guardian. An enduring guardian will make all non-financial decisions for you. These decisions may be where you live, what kind of health services you get, what kind of medical care you receive, what kind of services at home you would receive. All these come under the umbrella of an enduring guardian. Once again, when you appoint someone to be your enduring guardian, it is only enacted when you no longer have the capacity to make these decisions for yourself, and so this substitute decision maker steps in and makes them on your behalf. It is really important for you to share with who you're going to appoint to be your substitute decision maker. You can even write these in your enduring guardianship order. It is important that you write what you would like for yourself, as that will guide your enduring guardian to make decisions for you in keeping with what you would like. So for example, you might say that you don't want to be resuscitated, or you may say that you don't want to be in an intensive care unit and being intubated and hooked up to a life support machine. Or you may say that you don't want any artificial hydration or artificial feeding. The reason I say this is whoever is your enduring guardian is going to be left with making difficult decisions about your care, and it is so much easier for them if you have clearly written what you would like and what you would not like. Another issue that I'd like to talk about today is advanced care planning. Now, advanced care planning is where you write what you would like done for yourself, health decisions mainly, and really does focus on end-of-life care. If you still have the ability to write the plan for yourself, then that is called an advanced care directive, and you would write for yourself what you would like done. If, however, you no longer have the capacity to make those decisions for yourself, then someone else would make that plan for you, and it would be called an advanced care plan. Now, I urge you to check with your state. I urge you to check with your state, as each state has different rules on what the directive or the plan looks like. And you can either have it done with a solicitor or without a solicitor, but I urge that you involve your general practitioner or your geriatrician when writing these plans, as you would need to discuss with them what kind of scenarios could come up, and so you write what kind of plans you'd like for yourself in these events. Thank you for listening to me today. I just wanted to mention some of the legal issues that may come up during your consultation with a geriatrician, and explain why a doctor is asking you about these legal matters. Thank you and have a good day.